Thank you.
The hour. Hello. The hour having arrived. We're going to get started. There's a sign-up sheet. Is Representative Schofield?
I haven't seen her, but I did.
Well, we were going to let her go first.
Mr. Chairman?
She may, just text her. You know how it is. Everybody loves putting their meetings at 8 and 10.
Will never happen, right? Nobody do one at 9.
Am I spelling it wrong? When do y'all text her, apparently? Okay, we're going to go, this is the order we're going to do. We're going to do Kim Schofield, Matt Reeves, and the Longshoreman. Lisa, you want to open us in prayer or hit your button? All right, if y'all would, Chair Lady Hagan's going to start us in prayer.
All right. Thank you, Mr. Chairman. Let's pray. Heavenly Father, we're so blessed to live in this state, in this great country, and we do thank you for that. I pray that as we deliberate these measures in front of us today, that you will grant us wisdom, justice, moderation, and courage as we make these decisions for the people that we represent and for the state as a whole. In your name I pray, amen.
Amen. Okay, Kim, come to the table. My previous vice chair, Tom Kirby, I always get his input on labor bills, just because he can quote the entire section. And he has actually fought for this measure a couple of years ago, and then Kim's picked it up. So
Yes.
Go ahead.
Thank you, Mr. Chair, members of the committee. I, again, apologize. I had a low tire pressure, and anytime you see that, I have to stop. I get a little nervous. So. But this bill is simply a very short change in the code. When we talk about the workplace employees that are protected between certain ages, so they started at 40 and they capped it at 70 years of age. And we know that there are people that are working way beyond the age of 70. I was just looking at the committee to make sure I wasn't talking to our group. But so basically what it does is just it removes the cap, that as older people are in the workplace or more seasoned and senior people are in the workplace, we're just taking off the cap and not allowing anybody to not have fair representation in the workplace. We're capping it at 70 years old. That's all this bill does. It's a change in the code.
Okay, and technically an employer could let someone go.
Yeah, we have a right to work.
Because they could say, well, it's in the code, so they wouldn't be discriminating. So any questions? Is there what's the committee's will? There's a motion to pass. Is there a second? Second. All those in favor say aye. All opposed, no. Congratulations on the rules and good luck.
Thank you. Thank you.
And Vanessa's got a form in my office for the rules.
Okay.
Okay, next we're going by people signed, by the volume of people signed up, so I'm trying to knock them out as quick as I can. Is Matt Reeves here?
Yes, I saw that. He was in room, sir.
Well, in that case, okay. Let me do a little prelude because we have a couple of members who are fairly new. Y'all may notice this is probably the smallest numbered committee here in the General Assembly. There's a reason for that. Y'all are the brightest. And we have an advisory council attached to our committee made up of 100 folks, a lot of lawyers from both sides, from claimant lawyers to business community. And they take on issues when it comes to workers' comp, because it is as y'all have seen and heard, it is a very complicated issue. I'm making the decision to send this bill to advisory council. So they will come back with a recommendation next year, very early on in the session. So I preface that to let y'all know, hopefully that might lower the temperature on the pleading, since we're not going to take action. So that is the action we're going to take. It does not require a vote. It's a decision I'm going to make, because we had an issue like this several years ago. It will treat it fairly with that issue. So having said that, we're going to start and go with the folks who have signed up. And so several of us have, I know I've got a committee at 11. There's Rural Caucus at 12. So just keep that in mind, and we're going to go through that. So this is 82. So Les Snyder, come on up. And tell us your name and who you're with. Most of us know, and y'all can, podium might be better. Either one, podium or table. And tell us who you're with and your position and why.
Members of the committee, I'm Les Schneider. I'm not representing anybody particular on this issue. I think it's an issue that is something that the committee should hear and hopefully send a message to Washington, D.C. about the whole issue of the guest worker program.
Hey, let me interrupt you because my
Sure.
brain, I am not sending this bill to advisory council. The longshoreman, everything I said belongs to that. But we're not taking a vote on this bill today. The author listened to many of the folks, made a lot of changes. So if you hated the bill from last committee, please be open-minded. Listen, this bill is contingent upon the federal government doing something. I don't think they're going to do something between now and tomorrow night at midnight. So we're going to get the newest version on the website, which is what the author wanted, and it'll be ready for consideration next year.
Right.
So, thank you.
And I just wanted,
574 is going to advisory council. Some of y'all get old one day and have a brain like mine. Go ahead.
okay. Again, Representative Reeves and myself met with a number of the people from organized labor and gave some very good suggestions, and I can just quickly go over those additions that occurred in the bill. I just want to emphasize that, again, the purpose of moving the bill, whether we move it today or whether we move it next year, is to send the message to the feds on one major issue, that the state of Georgia ought to determine a labor shortage in this state and not the federal government. There have been numerous occasions where they either misstudy this or they don't give us sufficient numbers of folks in particular job categories. I'm looking at LC 28068-5S, and to give you some of the examples of the changes that we took into consideration is that we made it incumbent upon the employer that they would have to do a diligent search and provide the agency that's looking at the job shortage that they actually have tried to get U.S. citizens for these particular jobs, be it a nurse or be it a farm worker, et cetera, and they have to show that they made a concerted effort in their job search to make sure there was no U.S. citizens who could do and fill these job openings. So that was a very critical instance. The other issue, which I think was very clear, occurred, we added on line 67 to 70, and let me read it to you because I think it's important because there was some abuse going on, that a guest worker may only be employed in jobs in the particular labor category or occupation for which a labor shortage has been found. And then we specifically say that the guest worker may not be employed in jobs in labor categories or occupations in which no such labor shortage has been found to exist. Apparently, there were some instances where some engineers were brought over. They may have worked in an engineering position for perhaps a year, but then they started to do mechanic type work, and there wasn't a shortage of mechanics. So again, we're being mindful of that. In addition, we underscored the fact, and it's on line 122 to 123, that no person who has been convicted of a felony or any violation of immigration laws of the United States shall be eligible to be an employer under the guest worker program. So we were addressing perhaps employers that don't want to follow the rules of the road. In addition, we added an additional fine for an employer who fails to report the abandonment by a guest worker. He has to do it, he or she, within 3 days of the abandonment of such employment, so that, I think it was either Representative Peachtree or other people who made the point that we have to govern the fact that people shouldn't leave a job and then continue to stay in the United States. In addition, we reemphasized the fact that any employer participating in the guest worker program that employs a guest worker in a job category other than the particular labor category which we have established a shortage will be subject to a fine of not more than $10,000 for such each violation, not in the aggregate, but each violation is $10,000. The other thing we added was to make sure that any rules and regulations that are going to be addressed on any program that exists in Georgia would have to go through the Administrative Procedure Act, and that would mean that not only is there public comment by either the employer or the labor community, but that this committee, as well as its counterpart in the Senate, would have to okay those regulations. If you don't okay those regulations, then we go back to the drawing board all over again. So again, I just want to emphasize to the committee, there is no attempt by this bill to run a parallel program to H-2A or H-2B or whatever. It has to be the acceptable H-2A, H-2B program. And frankly, we're putting more belts and suspenders around that, not less. But the key issue is, and again, I know I'm repeating myself, but this bill is all about sending the message to the feds that the state of Georgia is better equipped to determine labor shortages than the federal government. And that we want the state of Georgia to study labor shortages so that we can get the right amount of guest workers in any particular job category that we need it, whether it's in rural Georgia, whether it's in urban Georgia, whether it's something across the state. That's what this is about. And to address, I think, Representative Bonner's issue, if you look at line 188 in the substitute, we're saying that even if this bill is signed, and even if the United States government says that Georgia can determine the number of labor shortages that exist and the number of workers that we need, and even if you all allocate the funds after you hear from the governor as to which agencies or agencies, plural, are going to be involved in this program. On 188, we're saying that even then, all the regulations have to be put in place, and you all would have to approve those regulations before anything could be done. So again, the federal government has to say, okay, the funds have to be appropriated, and all the rules and regs have to be before all of you for acceptance before anything could be done. And again, the main message of this is the employers in this state have to show the state that there's a job shortage. Then the state would have to conduct a study to verify that job shortage. And once all of that is done, then you begin to look at what is the best solution to the problem. So please don't ever feel that we're running a parallel track. We are just going to follow all the rules of H2A, H2B, but we can have more teeth in every one of those points, which I believe will increase more enforcement and will also result in the proper number of guest workers. So I hope I've given you a holistic view of what this bill is about, and I'll be happy to answer any questions.
Okay, and I appreciate the author and y'all listening to all the folks and making all these changes. Chairman Bonner.
Thank you, Mr. Chairman. Hey, thank you, Les, for addressing those specifics. A couple of questions, and I apologize if this was covered the first time we talked about this, but regarding the actual categories of jobs for a shortage. So is that to say then that the Georgia Department of Labor will determine what those categories are for job shortages? And it just from the mechanics of it, is that a dynamic list? Is it published once a year, twice a year? How often does it change?
The H2A, H2B program on the federal level, you've got to justify it every single year. And even somebody who was brought here in this year, if they wanted to stay the following year, they would have to also establish that there is still a job shortage in that category. To your point, let's assume for a moment Department of Labor is involved, but let's say they don't have the staff to do these studies to determine job shortage. It could be that one of the technical colleges who are able to do those studies will work in coordination with the Department of Labor. But again, the employer has to go first and show that they believe there's a job shortage because they've interviewed for the job, they've tried to get applicants, et cetera. They have to first show the state there's a job shortage, then the state does their own study to justify that job shortage. So my guess is that you're going to have more than one agency in this state handle this, because somebody's going to have the expertise to do the job shortages, to determine at those studies, and then you're going to have, my guess is, some enforcement, which probably would come from the Labor Department.
So even if this bill were in place now, there's still some, I would imagine, some other legislation that would need to surround it.
Yes, if you passed it tomorrow, you still would have to see all the rules. You still would have to expend funds to, fund this. We still would have to get the okay from the feds that Georgia can determine job shortages in this state. So there's no rush to judgment here. It's a message bill to tell the state, to tell the federal government that we want to determine the job shortages.
Yeah, understand. There's one follow-up, Chairman, if I may, and I appreciate that comment. I mean, I would say that it's like I tell a lot of folks that advocate up here. It's not that your issue is not important.
Sure.
Everything is important, but we have to look at the priorities and just the overall bandwidth that we have. So my question to you is, if we do nothing, if we take no action on this legislation this year, will there be a negative, in your opinion, a negative impact on Georgia moving forward?
I would say that if, in fact, this thing, let's say, passed through the entire process, it would be used for one purpose, and that purpose would be to talk to federal representatives, federal senators, and basically say, look, we know a number of years ago you had a bill in the hopper to let this devolve to the states in terms of the number of job shortages. Here's a state that is ready and willing to do that because they've passed a bill subject to a lot of conditions, but it shows you that we think the state of Georgia makes the better decision as to the job shortages than the federal government. And we would like you to pass federal legislation like you were thinking about 5 years ago that you didn't do. And that was done by two, I think it was a Republican House member and a Republican senator who both wanted that done. And it had bipartisan support. It just didn't move off the rank.
Sure. Thank you, Mr. Chairman.
Yep, and I appreciate you putting in the part about the APA that this body, the House and the Senate, would have a look at the rules. So I appreciate that. Who is that? You, Representative McLean?
Yes, Mr. Chairman. Thank you very much, Les, for you doing. I guess my only question, well, I shouldn't say my only question, but the question I have is I saw that the employer is going to take care of housing, insurance, and I didn't see anything about wages because, again, what I want to make sure is that we don't suppress wages by doing this, and I didn't.
Yeah, I concur with that, and when not, if you look at lines 101 to 107, they have to come up with that adverse effect wage rate, which has to be done all the time on any of the guest worker programs existing now. They do determine what the wage rate is for that particular job. So this is these guest worker programs never are done to make sure that somebody's wage rate is deflated. If an engineer is supposed to be paid $80 an hour or $100 an hour, then when they do these studies on the federal level, those wage rates are what come out. This is not a depression thing, but that's that section which comes from the federal law right now.
Thank you, Mr. Chairman. I guess what I'm concerned about was you as an employer, you're paying for my food, you're paying for my housing. I'm just trying to say, so I will still get my $80 an hour?
Yeah, on certain programs. Some of I think it's the H-2A requires the housing and the food and those. Somebody, for instance, who's being brought over here in an IT position or something like that, they provide their own housing and things like that because it's in a different job category. I think it's the H-1A. But what we have done here is basically mimic exactly what the feds do. If the feds say that you have to provide housing, then we're obviously going to provide housing, but it is not going to be reducing the wage accordingly. If the job is $50 an hour, then they may get their housing and their food in addition to that, not by a deduction. But there are certain jobs, very high-paying jobs, for instance, where those things are not required under H-2A, but the wage is still required to be the prevailing wage for that job.
Thank you, Mr. Chairman.
Okay. Chairman Carpenter.
Thank you. We sat in this committee and heard this a while back, and I was on my way down to Atlanta this morning, and I don't know if you guys listened to 95.5, whatever. And we can argue immigration policy, whatever, however we want to argue it, but at the end of the day, a meat producer in the United States is going to lose 150 employees if the folks from Haiti are sent back. If they get sent back, that's fine, but at some point we need a mechanism to allow others under strict guidelines to get here and fill those positions, because there's jobs, quite frankly, that people don't want to do and that live in America now. And so we need a mechanism at the state level to discuss with the feds what's important for our state. And with inflation, et cetera, that doesn't get better when you lose 150 people that are packing your meat. Your meat prices are not going to go down. So that's the first piece. The other piece is this piece of legislation reminds me a lot of Wes Cantrell's daylight savings time legislation.
Yeah.
Whereas the
Right.
state, we pass something but we're waiting on the feds, right? So we do that. That's something we do so that we are ready when the feds decide to finally get off the rear and do something important instead of fight with each other and clap hands and sit down all at the same time. So thank you.
Great comments. Is it Hagan? 25. Okay. Chairman Petrie.
Thank you, Chairman.
25?
No, I'm 25. 26.
Go ahead.
Thank you, Chairman. I'm not going to belabor the point because we're not voting on this anyway and never will if I have anything to do with it. But let me just say this. So I want everybody here to be clear on what you're asking for. So you're trying to compel the feds to allow states to have their own programs. So I want let me finish.
Okay, sure.
That's what you just said. This is a message to the feds. So I want everybody here to contemplate this. So Georgia has a program. You want California to have a program. We have sanctuary states in this country. So they're going to develop their own policies just like you want us to do. So I want everyone here, knowing what the American people think today, and knowing what the people of Georgia think today, to contemplate that. That's all I want to say, Mr. Chairman.
And my only response to Representative Petrie is I don't want Georgia to have their own program. What the request here, and I believe Representative Reeves was here, is to say that we have to abide by all the rules of the feds on the H-2A, H-2B, et cetera. But the only difference between what's happening today is that the feds are determining how many guest workers should come into the country, and that I think it should devolve to the states to determine the number of guest workers that come in the country. That's the most significant part. We would still be following all the rules of H-2A, H-2B, et cetera. We would only be addressing the number.
Okay. Cameron, did you have your button put? Go ahead.
I did, yeah.
Go ahead. I got
That's
you
okay.
back on.
That's all right, Jesse. My question, are there any states surrounding Georgia that are trying to do what Representative Reeves is trying to do?
Are there any of the states around Georgia? There have been states that have discussed this issue. I think we would be on the cutting edge in terms of sending a message bill to the feds. I'm not aware of other people, but I know there's been other states have been more successful in, I think, like South Carolina, in acquiring more guest workers. They have worked through the feds somehow. But at the end of the day, I think like we do things here, like TAVT, and we do things here, perhaps on property tax evaluation, getting rid of personal property taxes, that we were on the cutting edge. We were the start. So the position I guess I would take at this point to your question is that there may be other states working on them, but I'm not aware
Mr. Chairman.
of those states.
Yep, go ahead.
Has anyone engaged anyone at the federal level about their thoughts on this?
I talked to some of the aides of the rep and the senator who brought the first bill to let it devolve to the state as to number, and I have had some discussions with some of the federal reps and senators here about this.
Thank you, Mr. Chairman.
Okay. All right. Last one, Representative Holly.
Thank you, Mr. Chairman. Hey, thanks, Les, for coming and always enlightening us. Curious for if you could tell me, I appreciate when you were saying literally that the employers are the ones who tell the state in terms of the numbers that the job shortages that there are. How is it? How are they able? In what process do they determine that shortage?
What the employers would do is they would have to show that they advertised for these jobs, that they interviewed people for these jobs, and even, they may have had 10 positions, and they may have been able to fill 2 slots. They would have to present that evidence to the agency that's doing the job study to say, look, we really have a bona fide job shortage. It's much the same way when they are trying to attract perhaps women into certain job categories or other folks to say, we have a problem with this. We have expanded our job search. We have gone to these areas to try to locate people, but there's a shortage of people graduating in these particular jobs. For instance, perhaps there's not a shortage in metro Atlanta for nurses, but in rural Georgia there may be a serious problem attracting nurses or doctors there. So they advertise. They have to give some palpable evidence that they have done due diligence to try to receive and get U.S. citizens for these jobs.
Let's, we had one other person, James Williams. Were you on this bill? Okay, go ahead. Go ahead.
Yeah, first of all, thank you, Chair and Committee. And I do want to thank the author of the bill for reaching out to us and listening to our concerns. We feel that there's more work to be done with this bill, and we look forward to continuing that conversation so we can draft a good bill. But on the gentleman's point, I've 20 years as an electrician in the field doing power plants, data centers, all the way down to residential properties. And if you look at the category, some of the building trades are on that list of work shortages. But I don't believe there's a worker shortage. I believe there's a wage and benefit shortage. And so one of the points I would like to make in this bill is they can go ahead and advertise, and I would like to see part of the metrics that they use to prove that there's a shortage is what are they offering compared to those facilities that aren't having a problem. If they're not offering the same pay and benefits, they're just kind of doing this study and proving they got the advertisement so they can get the visas. So there's a few more points. I do like the changes that were made to the bill, and I'd like to continue working on this bill.
Thank you very much.
You got it.
Okay. We're not going to take any action on this bill. Appreciate it, Les. Y'all continue to talking to the author. We're going to move on to Chairman Stevens. Come on up.
Thank you.
And it was kind of a late decision. Sorry, I didn't give you more warning than that. But again, it's pretty customary for this committee to pass items like this on to the advisory council. So go ahead and come to the table. Was there any changes to the bill from last time? I don't think there was there?
And again, I want to apologize for the folks that have driven long distances without a heads up that their bill was not going to be heard today, Mr. Chairman. This is a competitive issue. Currently, the longshoremen have a workman's comp policy. They have one that covers them with all of the states that the Georgia ports competes with, every one of them except South Carolina. Now, if their bill passes this year, Georgia will be the only state in the country that has this duplicate coverage. Ladies and gentlemen, I'm telling you, the lawyers behind me love it. They're praying we don't do anything on this stuff because they get to bounce back and forth. Let me tell you what the longshoremen get for life. They cover their lost wages and they cover their medical. And unlike Georgia workman's comp, it's for life. Ladies and gentlemen, we need to come to a resolution on this stuff. It's unfortunate that we're putting it off another year. We're going to be less competitive. We'll be the only state in the country. Florida, New Jersey, New York, Pennsylvania, Virginia, the states that our ports compete with are going to be at a competitive disadvantage because it's an additional cost. And the only winners, it's not the injured employee. The only winners in this is going to be the lawyers that love to bounce back and forth between Georgia workman's comp and their plan. And Mr. Chairman, I'll turn it over to somebody else that drove all the way down here to be told they're not going to hear it this year, but they'll be back next year because we'll be the only one left. I'll answer any questions.
Okay, Chairman Carpenter.
Yeah, I just want to, I need some clarification on this because we've heard 7 sides of this thing. And I need clarification that the federal standard is 6 years on workers' comp. If they apply for the state workers' comp, let's say they do 3 years before the feds get their act together, are they then allowed to add 6 to the 3 to make it 9, or does the 3 get taken out of the 6? That's my question.
Chairman Carpenter.
And I may have the numbers wrong.
We have a subject matter expert here, and if we could bring him up, he came up from Savannah to speak.
Okay.
And he can clarify any confusion and explain it a lot better than I can. I hope, Matt Campbell, by the way, that possibly you'd respectfully consider delaying the decision to send this to an advisory council until we hear this testimony and all the facts. That last meeting last week, it came out of, was dropped and then heard the next day, and these professionals were not able to be here, so we kind of only got information from one side, and the little bit of confusion, that I provided obviously didn't clear up anything. But Brian McElreath is here, and thank you.
Go ahead.
Hey, Chairman and Committee, thanks for having me. Representative Carpenter, to address your question specifically, you're saying if they file Georgia went 3
Hey,
years.
speaking to the mic, because we're being live streamed and all.
Yep, my name's Brian McElreath. I'm an attorney that represents insurers and stevedoring companies, shipyards along the Georgia coast, throughout the southeast, but specifically in Savannah. You were asking specifically about if a injured worker files a Georgia claim and goes for 3 years before the federal gets their act together, could they add 6 years? Was that the question?
Yes.
Yes, sir. So the Georgia State Act is capped at 400 weeks of compensation, roughly 8 years total, give or take. The Longshore Act is for life, so they can get benefits for as long as they require them. Does that answer your question?
Yeah, well, yeah, I mean, it kind of does, but so.
What's your number?
Yeah, it kind of does. So okay. I was thinking that it was a 6 year. So what's the argument that it's currently delayed, the feds are delaying those benefits?
Yeah, I would say from my side that the feds are not delaying the benefits. So under the federal act, you have a 3-day wait period before benefits are initiated. Under the state act, you have a 7-day wait period before benefits are initiated. The statistics that you all have in front of you from from Gateway Terminal specifically, say that on average, benefits are initiated between 12 and 14 days, whether you look at from the date of report or the date of accident. Someone could get hurt a week ago, but not tell us about it until today. So it's a 12 to 14 day window from when the accident occurs or from when they tell us about it on average to when they get their first check. The Longshore Act, vastly superior benefits. You're getting roughly $2,000. You're getting $1,999 and some change. So roughly $2,000 a week if you're a high wage earner. Under the Georgia Act, you're getting $800 a week. So you're getting 2.5 times. You're also choosing your doctor under the Longshore Act. Whereas the Georgia Act, you have to choose from a list of doctors that the employer provides to you. You get your benefits for life. One of the questions last week was, well, is there duplicative coverage? There are roughly 10,000 people in this state covered by the Longshore Act, which I think is highly less. I think there are 11 million people in Georgia. That's about 0.08% of the population. 99% of your constituents are only covered by one act. Both of these acts, the Georgia Act and the Longshore Act, were designed to be, they were drafted by the legislature to be exclusive remedies against the employer. Due to the timing, there's a gap. There's a Supreme Court case that says, Sonship, that says if you didn't explicitly rule out concurrent coverage, the Supreme Court's going to allow it. But you're definitely allowing double coverage. Now, would all of your constituents have additional benefits if they were covered by two acts? Absolutely. Does it create inefficiencies into the system? It absolutely bakes inefficiencies into the system, and because it creates what I call this kind of a Frankenstein problem, right? The statistics you have in front of you say that on average, someone, for the reasons we just talked about, you get paid 2.5 times more, you get to choose your doctor, you have benefits for life, your attorney's fees are paid in addition to your money rather than out of your money as they are under the Georgia Act. So you're not having to pay your attorney. The employer and insurer are paying your attorney. So for that reason, injured workers typically choose to proceed under the Longshore Act, as anyone here would if you're getting paid 2.5 times more and you have superior benefits. So then they go way down this road, and then on average with Gateway, 244 days into a claim, which is when most folks are on average are about to go back to work, then they start pursuing a Georgia state claim. This is where the inefficiency gets baked into the system, because now you're asking adjudicators under the Georgia State Act to craft a remedy when the rule book that they've been playing out of the whole time is a Longshore federal rule book. It's a different rule book. And you're bouncing over to the state forum and saying, Madam Justice or Mr. Justice, this is what we've had to date under this other federal act. Can you craft me a remedy under this state act, which wasn't designed to craft a remedy because you didn't play out of the state rule book? That's where the delay comes in. And I'll tell you, as I mentioned, I try these cases throughout the South, and Georgia, or Virginia and Florida are both exclusive jurisdiction. Does it take a little longer to get a federal decision back? It absolutely does. But in states where there isn't concurrent jurisdiction, you get a decision back quicker on average than you do in Georgia and South Carolina, because there's this Frankenstein problem of you've got to try to interpret this other rule book that you're not used to playing with, and you've got to sort out all these credits and the leakage out of the system and the inefficiencies, and things are scheduled over here and they're not over there, and attorney's fees are in addition to under the federal act, but they're taken out of your money under the state act. Does that explain the question to some degree?
Yeah, I mean, I think so. I guess my other question, and I apologize, I should do a little more research before I get here, but the employee's getting paid whether the decision has been made or not on a week-by-week basis from the feds.
So the statistics you have in front of you will say that 90% of employees in gateway terminals are paid. 10% of those claims are denied. 90% are accepted. That 90%, they're getting paid on a weekly or biweekly basis. If it's biweekly, you're getting 2 weeks check like you would a paycheck.
Mm-hmm.
All right. Chairman Bonner.
Thank you, Mr. Chairman. Thank you for coming here to testify. It certainly means a lot. Just a couple of questions. I grasp pretty well the kind of the financial impact of these premiums and all. Talk to me about the loss of the worker. I mean, how is that impacting the port and the functioning of the port? Because it seems to me that with the way that the federal option is available, am I correct to think that an employee would be out longer if they pursued both claims?
So possibly. I think what the statistics from Gateway bear out is that typically 244 days into a claim, a person starts to pursue a Georgia state claim. That's because a lot of port injured workers injure their shoulders, they injure their backs. Under the Longshore Act, the federal act, if you don't have restrictions preventing you from going back to work, you can go back to work, and if you're not losing any wages, you're making the same money that you were before, then the value of that claim goes down to zero because you're back making the same amount of money, the system has worked as it should, and you've received your benefits while you've been out. Under the Georgia Act, that shoulder and that back are what they call scheduled injuries. It presumes a wage loss even if one may not exist. So if your doctor gives you a 10% rating to the back, even if you've returned to work with no wage loss, you can still get an extra 30 weeks of compensation at $800 a week, roughly $24,000. So it does prolong the system. So in that case, those injured workers would be losing $25,000. Absolutely. But 99% of your constituents don't get $2,000 a week, right? The system it's a give and take.
No, I mean, I get that. I guess, I'm sorry if I'm not asking the question properly, but I'm looking at the loss of the worker, right? I mean, in terms of if there were no federal Longshoremen's Act in Georgia, the amount of time, presumably, that employee was out of work would be less. Now it seems to me that they have the option to go under the state claim and for a period of time, because there's no requirement to file those at the same time, correct?
That's correct.
So
by filing one, you told the ability to file the other. You can file it 4 or 5 years into your claim.
So presumably they could go through the state claims process and be out of work, and then towards the end of that process file federal and be out of work for whatever amount of time it takes to adjudicate the federal claim, correct?
Yes, Representative, or vice versa. It could go in the other direction.
So we're not only talking of kind of a financial cost of what's being paid out, but we're also looking at the additional cost to the company as to losing an employee. So productivity, I guess, is what's being lost, correct?
Absolutely, and
Okay.
I would say, I think Gateway personally employs 3,700 people, but it drives 9% of GDP in Georgia.
Understand. And then, I'm sorry, one kind of follow-up question is, and if it's in the information, I apologize, but is it fairly standard or consistent that employees do file both? I mean, are there any numbers to show that everybody's doing it or only half are doing it, or is it, what are the numbers on that? Do you know?
I would say, in my anecdotal experience, 95% that become represented do. Now, I only see 10% of these claims because 90% of the time, the system works as it's intended. An injured worker gets injured, the insurance company pays, and they go back to work.
Yeah.
So of that 10%, I would say 90 to 95%
Okay.
file both.
And I'm sorry, one last question. In terms of other states that don't have the federal act, are we? Is their state compensation? Are we competitive with those states in terms of our state compensation?
So every state has the federal act, but some don't have a companion state act coverage. Georgia, the max comp is $800. South Carolina, which does have state and federal, the max state rate is $1,000. North Carolina, because of the triangle, it's like $1,200, drives it up a little more. Virginia is low, $1,000. So I would say the $800 is competitive. Yes.
Thank you. Thank you, Mr. Chair.
Representative McLean.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I guess, when I hear the word competitive, duplicate, bounce back, double dipping and stuff like that, I really get partially concerned. But so what you're saying is that if he's drawing state, he can't draw federal. And if he's drawing federal, he can't draw state.
Well, if he's thank you for the question.
Yes.
If he's drawing federal, and we're assuming in this hypothetical that everyone is subject, they're high wage earner, correct? And so if he's drawing federal, he or she, they're getting paid 2.5 times what they would get paid under the state. If they're drawing state, they can get their $800, and if they have a really good attorney, like the gentleman sitting behind me, they will also go and get the additional overage under the federal, so they will get both. Yes, sir.
Okay, Mr. Chairman, I guess, okay, so what you're saying is that he gets $800 from the state, and then if he gets $1,900, that the federal is going to pay him back the $1,100 a week or whatever he missed? Is that what you're saying? Or it starts the next month with $1,900? I mean, I want you to be specific now. I want to help you along because I know what you're saying, yes, because to me that's double dipping. If you're getting $800 and then they go back and give you $1,100, that's double dipping. But if you only are getting $800 right now, and then when you do get your federal, you're getting that amount of money that you should be getting, that's not double dipping because you can't get the $800 once the federal take over. Is that correct?
In the example that you gave, if you were getting $800 under the state, you could go get your additional $1,200 under the federal in addition to. 99.9% of the time, it does not work that way because the benefits are so vastly superior under the federal. They go the federal route, and they don't bounce over to the state until 244 days in at the nearing more the end of the claim.
I'm sorry, Mr. Chairman, I guess you really confused me because you're bouncing over. Is he bouncing over to, is that when the federal normally kicks in? I don't know because what I heard the last time is that the reason that they do file both is because the state may kick in 2 months or 3 months or whatever, but the federal takes 4 to 5, maybe it take 2 or 3 years or 4 years to kick in.
I can address that for you.
Yes.
Yes, sir. So I think that example would be the 2 to 5% of claims, or in Gateway's terminal, maybe the 10% of claims that get denied. That person is not being paid because maybe there was a positive drug test, maybe there are credibility issues, there is some type of issue that has arisen, and that claim has been denied. It has not been accepted, so that person has not been paid. So what you heard last time was you have a quicker avenue to a state hearing, to get in front of an adjudicator so you can plead your case and I can try to win the hearts and minds on my side. You have a quicker avenue to the state. But the fact of the matter is that never happens because under the Federal Act, 33 U.S.C. Section 920, there are presumptions that are in favor of a claimant, an injured worker. Presumptions that say there's a presumption that your injury arose out of your work. There's a presumption that says you're presumed that your injury wasn't caused solely by intoxication. Georgia has the exact opposite presumption. If you don't present yourself for a drug test, then there's a presumption that your injury arose out of intoxication. So if that 10% of claims, some percent of them is going to be alleged intoxication, right? Some minor 2%. Well, if you have a 2% intoxication case, you're not getting paid anything. Even though you've got a quicker run to a hearing in the state forum, you're going to go to the federal forum because you've got a presumption that helps you try to prove your case. You would be an idiot to go to the state forum. We've got a presumption against you when you can go over to the federal where you've got a presumption for you.
Thank you, Mr. Chairman. I just want to say thank you very much. So what I'm hearing from you is you're on the employer side. So I need to make sure I hear from the worker side because right now I think the workers enjoy what they have right now. What they have, I don't think there's not one worker would not enjoy what he or she would have under what they have right now.
Yes, sir. Yeah, I think that would be true for the whole state. If the other 99% of the state had two coverages, I think they would enjoy that. Yes, sir. And I am on the employer side, but just so you know, I'm advocating against my self-interest, right? Like I get paid more to defend two claims, but it's better for my clients. I think it's better for the good folks of Georgia if it's exclusive jurisdiction. I think you keep a competitive edge on South Carolina and you keep a competitive edge for the port, which helps to employ more good Georgians in very well-paying jobs.
All right, let's keep going. Representative Barton. Who's 26?
That's me.
Okay.
Thank you, Chairman. Mr. McElreath, speak to me, if you could, about clarify an issue on employer costs as it relates to defending themselves and claimants. So tell me how that's impacted with this concurrent coverage.
Sure. Well, I think there are a multitude of employer costs. Right out of the gate, you have to procure two policies. So you have dual coverage costs. And then you have to procure dual defense. You either have to pay me to defend you in two jurisdictions, or you pay me to defend you in the federal jurisdiction and some other state attorney to defend you in the state jurisdiction. And then, although you heard last time there are credits, but there's leakage out of that system. If you go pursue something under Georgia, as everyone here knows, the legislature has crafted that system there's a 25% contingency fee that's taken out of the injured worker's money. I only get credit for that 75% when you go over to the Federal Act. So there's a 25% leakage that's coming out. It's not a full 100% dollar for dollar credit. I'm getting 75 cents on the dollar when I go back over. So I think the cost, and then the litigation is prolonged because of the confusion, because you're asking state ALJs in Georgia to craft remedies from federal issues. You're asking federal ALJs from Newport News to craft remedies from someone that's been proceeding under state issues. You're going in front of 95% of these cases are folks 244 days into their claim going and trying to get paid for a scheduled rating, which I don't blame them. That's what they're entitled to do right now. As well they should. But the problem is they're not playing out of the rule book that allows them to get paid for that rating. They're going and getting paid for a rating from a doctor that they've chosen, whereas if they had gone under the state system, it would be a doctor from the list that the employer gave them. So now you're going to that state ALJ and saying, pay me for this rating, but you didn't get your rating from the way the Georgia legislature designed the system to work. You're using a different rule book, so that's another cost. I think there's just all kinds of inefficiencies baked into the system the way it currently is. Virginia's done away with it. Florida is exclusive. South Carolina and Georgia are the biggest port states that still have it. As you all know, the Savannah port has lapped Charleston. The only way Charleston will catch up with you is if they go first. This will happen eventually. And if you let Charleston or South Carolina go first, it could be the great equalizer that brings them back up to speed with the Savannah port.
Chairman Carpenter.
Yeah, let's talk about this from another area. Is there a way to, if we required them to file claim in boats at the same time, would that solve that? Would that prevent this wait until day 244?
Well, most of the time they are filing the claims at the same time. They're just not pursuing the state until the end.
Okay, so you can file and then just let it sit over here like that right there, and come back and get it in 4 years or whatever.
Yes, Representative.
Okay, that don't solve it then. Okay, thanks.
Representative Holly.
Thank you, sir. Tell me something. Since nothing changed in this bill from the last time we heard it, do you have anything that shows where individuals have actually been granted money at the same time? Because, I mean, I've got, the only subject matter expert I've got is the Merriam-Webster dictionary, right? In 194 years, it's been made in America, and it just defines a double dip as obtaining money from two sources at the same time. And I have yet to see or hear anything that shows where individuals are getting the money at the same time, because all I've heard is that by filing it at the same time, that equates to getting it at the same time, and I just haven't seen any proof of that. Do you have any?
I would say neither system is designed that way. If you're getting paid weekly benefits, then you can't go get permanency.
Right.
You can get additional benefits, but you're not getting.
It's not at the same time.
No, I think we've established that is not happening.
All right. So if that's established, then are we just? Is it clear? What is it that the business community would be suggesting to injured workers who, if they go on with the long-term federal act, that may take them upwards to 5 to 6 years, and yet they're injured? Because if we're just given the faith that the business community has an idea, what would that be in order to allow for productivity to continue? Is it to allow for injured workers to still work even though they're injured, even though they have to wait for 5 or 6 years? I think that part, for me, if you could answer that, that'd be great. Because I get the contention to put it on to the feds, and we know that it'll be 4, 5, 6 years. But if, I'm a single man. But if I had a wife, if I had kids, I have a family, and, I'm probably not going to sit and wait. So is the contention by, what would be the response for the business community then, if you want to make sure that people are still able to get their benefits, you have no problem with them filing? How does a business stay productive if you know that your injured workers are going to be sitting around waiting until they actually get their claims?
Well, I would say first of all, the stats from Gateway would say this is a 1 out of 10 person that you're talking about. 90% of people are picked up and paid within 12 to 14 days. So we're talking about that 10%. So that 10%, I guess, if you do away with the inefficiencies, one, it's going to cut down on the time that it takes for that adjudication. But there's always, whether you're going the state or the federal system, there's delay baked into due process, right? Like both sides have a chance to, if I'm saying, you, sir, were intoxicated at work, you have a chance to go prove that you weren't, and I have to prove that you were, and I have that burden. So there's always some small delay in there. Just to clear the record, as for me, I don't know what else you all have heard, but I haven't said the word double dip. I do think there are vast inefficiencies and leakage out of the system. I think injured workers, who I greatly respect, especially port workers, they do very hard work that keep the economy moving and drive 10% of the Georgia GDP. I respect them greatly. They're currently availing themselves of the system that's available to them, as well they should. Florida doesn't have that system. Virginia doesn't have that system. Shortly, Georgia or South Carolina won't have that system, and I think I would say the business community doesn't want to go behind South Carolina and let them catch up, because Gateway currently employs 3,800 people. Mm-hmm. If it continues to grow and maintain its competitive advantage, it can go to 55, 6,000 people, and these provide good, hardworking folks $150,000 to $250,000 a year jobs that don't require a college education and $100,000 in student loan debt. That would be my response.
Okay.
So I got one question. They all got 5.
So
Yeah, we're
can I
going to keep moving. Vice Chair.
Chairman, can I just briefly to Rep. Polly?
Yep.
Thank you for, I'm just going to come, so
Get to the mic.
I worked under the Railway Labor Act, which is a federal act about 100 years ago, just like the U.S. Longshore and Harbor Workers Act. Not just like, because one's on rail, one's on water, right? But I would say those longshoremen who are hardworking people, just like the railroad and other crafts that we have in this country, 100 years ago, a lot of men and women fought for that federal act and that great protection, as well they should have, and they deserved it, and that's why it's so far superior. And so this is, and I would never intentionally, you know what I mean, and I don't believe at all that this would hurt the worker. What we heard today was the federal, I think within 3 days, right, you get covered. And where the delay comes in is when the confusion comes in down the road when they choose to pursue extra or whatever under the device of bad counsel or good counsel, whatever way you want to look at it. Right, so it's not the long-term act, it's the Longshore Act because of the craft, as the Railway Labor Act, which is something that's very coveted by both worker and the employers who, uphold that. So that's all I wanted to chime in on.
All right, Representative Seaball.
Yeah, you may have just answered my question, but as an employer, I understand where you're coming from. I certainly wouldn't want to pay for two benefits. But from another standpoint, I want to make sure my workers are taken care of. So just because I think what we've heard in prior testimony is that the federal plan takes for a long time to make a decision. What's happening with the employee that injures their shoulder, they're out of work? Are they getting paid until that decision is made by workers' comp at the federal level?
Thank you, Representative. I think the statistics bear out that between 90 and 95% of those folks are getting paid. 5 to 10% of those folks, those claims are being denied because they have credibility problems. It was an unwitnessed accident. Maybe they tested positive in a drug test, or there was some issue that arose. But 90 to 95% of those folks are being paid during the pendency of their claim. 5 to 10% of those, the drug test, the credibility issue, whatever it may be, they're not being paid, and those are the ones that typically require my involvement or the good folks, the gentleman sitting behind me's involvement.
So I was led to believe that the state plan would cover that while the federal program was trying to make up their mind whether they're going to do something or not.
Thank you, Representative. No, so in 99% of these cases, I represent both the state and the federal. I've never had one case where it was denied federally and then it was picked up state while maintaining a denial under the federal. If it's denied federally, it would be denied state-wise. And you would have a quicker run to a state hearing. The Georgia system allows for a more efficient avenue to a hearing, but the simple fact of the matter is that is not pursued because of those presumptions that we talked about earlier that are so powerful under the Longshore Act. Those presumptions are they're a siren song for the injured worker because you're going to want to go where you have a presumption that your injury is covered.
Yeah, I just want to make sure that the employee's not being penalized for the process, for the inefficiency of the process that either benefit has, because they have families they got to take care of and those kind of things. So that was my biggest concern. I appreciate you answering the question.
Thank you.
Okay, let's hear from, we got 2 other people. Ralph Lieberman, you can come to the podium or. Okay, did you have a question for him? Okay. All right, go ahead.
Thank you. Thank you, Mr. Chairman and members of the committee.
Yeah.
As you may recall, my name is Ralph Lorberbaum. I'm from Savannah, Georgia, and I only represent injured workers under the State of Georgia Workers' Compensation Act and the Longshore and Harbor Workers' Compensation Act, and have been doing it for over 45 years. I'd like to address as quickly as I can things that I did not discuss last week, but what were mentioned today. and one of them is about lifetime wages and lifetime medical care under the Longshore Act. Well, in order to get lifetime wages, you have to be permanently and totally disabled. Because once you reach maximum medical improvement and go back to work, you're not entitled to get workers' comp, whether it be state or federal. And the lifetime medical care, if you get injured, you are entitled to medical care for the rest of your life for that injury, if and only if the medical care you're getting is causally related to your injury and not some new condition. You go and slip at Kroger or Publix or in your front yard, that can cut off the liability. Why should Gateway have to pay if you're in an automobile accident 6 years later and you're suing a driver for an aggravation? So that's not correct that you get unlimited wages in medical care. As far as whether or not you get to pick your doctor and you get a rating and that's killing the employer, well, if all this is true, how am I even in business? The insurance company and the employer have a panel of doctors that they use in the state claims, and they are entitled, as long as you are trying to get benefits under the Longshore Act, have the right to send you for a second opinion from a doctor of their choice. And obviously that's where the dispute comes up. They have a doctor that says one thing, the client injured worker has a doctor that says something different, there's a dispute, that's why it has to go to a trial. An injured worker who can't...
Can I pause you for 1 second, because we're about to lose quorum. On Reeves' bill, the whole purpose of his presenting, he needs to get the latest version on the website for next year. Can I get a motion to table his bill?
Motion to table. Second. The table will get it on the website.
This is motion table.
And it would need to pass.
Did you check with the clerk's office? Would that do it, or do we need a do not pass?
Just, no, to table with the current version, I'll work with them on that.
Okay.
Second.
So we have a motion to table, a second. All those in favor say aye. All those opposed. Thank you very much. Sorry about that, but most of us have to be at 3 places at one time. Go ahead.
If a worker has a pending trial under the Longshore system, the question was asked of Mr. McElreath, well, can't the worker go back to work while he's waiting the 5 or 6 years? Well, sure he could. However, that changes what his claim is about. He may have been claiming what's called temporary total disability, where he can get whatever 2/3 of his wages are. But if he goes back to work, he's already now proven to a judge, I'm not totally disabled anymore. I'm only partially disabled. So he can go, but then he's giving up money that he could win or possibly win under the system. I can tell you that I don't think there's a question anymore about the double dipping. An injured worker can never get more than the maximum rate he would be entitled to under either statute. So if he's entitled to a maximum $1,200 under Longshore and he gets $800 a week under state, then he's only entitled to claim the additional $400. So he can never get both. He's getting them both, but once he starts getting one, the employer is entitled to a credit if he goes and gets it under another statute. As far as attorney fees coming out of the employer's pocket, because they don't get a credit for the attorney fees, they get a credit for every dollar that the claimant puts in his pocket. And if he has to pay out attorney fees, he doesn't get a credit for that. Attorney fees are not always paid by the employer in a Longshore case. There are requirements to be met. So these presumptions don't really always apply. I think we covered a lot of this last week, and
Okay. You got a question, Chairman Carpenter?
Thank you. I appreciate you being back here. Quick question. What percentage of your cases goes through the state process before completely through the state process before the federal process?
10 to 15%.
So of the 90%, of the 90, we're saying 10% actually do what we're talking about now. And you're saying another 10% of that goes through the state first instead of waiting till the end to go through the state. So 1% of total workers' comp claims in this area go through the process where they deal with the state first and then deal with the feds.
And as I said, about 15%. And the reason is sometimes, I have clients that have multiple families. They have children, marriage, another marriage, more kids, mortgages. They have child support liens. They can't afford to wait 5 or 6 years to get a decision in the federal claim, and they have to try to go, and even if they're only getting $800 a week, if that's how much they're entitled to, they would rather have that than nothing, and they can wait.
Sure, yeah, and I don't disagree with that. I don't disagree with that statement. The heartburn that I have is that you're on the federal program, which is more robust and more beneficial, and I don't blame you for being on that. But I have a problem when you bounce back into the state because the feds don't offer the back pain 10% or the shoulder pain 20%. Like that to me, with all due respect, is double dipping. Like you can't have your cake and eat it too. You can't live over here on the good program and bounce to the bad program when it's convenient.
Well, that
doesn't make, you know what I'm saying? I understand the guy that's going to the state to begin with because he's broke and he's trying to feed his family and he's waiting on the feds. But going to the feds first and then pouncing back to the state, that's a little disingenuous, I think. I think that's a fair comment.
First off, if the injured worker is claiming total disability, it may not be permanent, but he can't work. He hasn't had surgery to his shoulder, hasn't had surgery to his back, whatever it is. If he's claiming total disability, he can't wait 2 years into the system and turn over to the state system and say, I want the 10% to my shoulder, because he won't have been given it. Now remember, he can't get more than what the maximum is in any given week.
Yeah, I understand the 2,800 comment. I understand the 2,800 deal, and that if he's getting 8 from the state, the feds will back it up with $1,200. I get that math. But what I don't get is you living in the world where you're in the 2,000 world, and then when it's convenient to bounce back into the state program to get the percentage-based compensation, you do. Because that to me says, you're the reason we're having, that's the reason I think we're having this conversation.
I respectfully disagree, because if you're not getting anything under the Longshore Act, because they don't give a scheduled injury to your shoulder or your neck or your back, so you're getting 0, and now you go and get the percentage from the state, there's no double dipping. You're only getting it from one source.
But you're getting an additional $1,200 a week from the feds, so you've picked your position on the injury by saying, I like the Fed program because it's $2,000 a week. If you're more interested in the 10% for your back, then stay in the $800 program.
Well,
but you see what I'm saying? Like you can't get the $2,000 a week. It's not fair to get the $2,000 a week pay, and then say, yeah, but I want to go back down here and I want to get my percentage pay now for my injury, which is set up because we're only paying $800.
You can't get them both at the same time.
No, I'm not saying you can get them both at the same time, but you can get them afterwards. And what I'm saying is I'm driving down I-75 to Florida, and then all of a sudden I want to cut over and go down 95 to get to Jacksonville instead of going to Orlando. Like you pick a path.
Well,
you're abusing the pass.
What's going to happen at the end of 400 weeks when you can't get any more state benefits? State benefits stop at 400 weeks.
Absolutely.
Okay.
And I don't have, and I just said I don't have a problem if you start in the state, but to start in the feds and bounce back into the state when it's convenient, that 15% of your cases, is why we're having this conversation, I think.
So if an injured worker gets hurt and the employer says, well, I want to dispute it because I have a doctor that says you can go back to work, and the injured worker says, well, my doctor says I can't, and you now have to wait 4 or 5 years for a decision, and in the meantime, your body heals without surgery. Okay?
Yeah, listen.
So why isn't he entitled to go ahead and get some money? He may not win his case down the road in the Longshore Act. So why isn't he entitled to get his $800 a week under state?
My problem is not starting with the state. My problem is finishing in the state. If you want to start in the state at $800 and then move to the feds and get $2,000, that's still not a problem because you're still gonna cap out at $2,000. The problem is when you get to the feds and then you want to bounce back to the state at the end to get the percentage piece. That to me is an issue. And I mean, obviously it's a disagreeable policy, but I think at some point, you know, the proverbial you can't have your cake and eat it too. Like, choose your path. And as counsel, you provide them with the guidance to choose the correct path and not the path that abuses the system that brings us to this situation.
So according to my statistics, 21 states have concurrent jurisdiction. 17 states don't. That doesn't add up to 50 because the states that are in the middle of the country or the Midwest don't have navigable
Sure,
waters.
fair enough.
So there's only 38 states that you could possibly have concurrent jurisdiction. And the majority of the states do allow it.
Okay, let's hear, we've got one more person signed up, Bruce Caraway. If there's no more questions, I appreciate you traveling. I know most of y'all did not come from down the road, just like half of us. All right, tell us who you are.
Thank you, Chairman Workhauser. I'm Attorney Bruce Caraway. I practice in the state of Georgia. I handle Georgia workers' comp cases, but also I do longshore cases, kind of like Brian McElreath do it throughout the Southeast. So I do have a perspective of what happens in Florida where there's not concurrent jurisdiction. I would contend that Florida is the law that has Frankenstein. I had a case in Florida where the worker's job was to go out on a pier. He had to paint the electrical house that was used for the ships coming in. So he's a painter. He goes onto the dock. It's a pier in Key West, so it's longshore. But he's normally not on the pier, so he doesn't necessarily have status to be under workers' comp, but the location of the injury is longshore. And so what we had happen was the state of Florida carrier said, hey, it's not state of Florida, we're not going to cover it. And Longshore said, wait a minute, he's just here temporarily, we're not going to cover it. So basically, because there was not concurrent jurisdiction, they could take conflicting positions, not pay his benefits. And this man had an accepted case. He had a herniated disc from lifting 5 gallons of paint. Nobody denied that he was hurt, but they said there's this legal monstrosity of we can take conflicting opinions. I didn't come up with that language about legal monstrosity. If you look at where the United States Supreme Court case of Sunship v. Pennsylvania, this is where the concurrent jurisdiction issue came up. The issue to the Supreme Court was, do we let concurrent jurisdiction or do we just go with state, or is it totally preempted by the federal law? And what the Supreme Court, the language they used, if they didn't do this, they would thereby be resurrecting the jurisdictional monstrosity that existed before. So if we take away concurrent jurisdiction, we're creating a jurisdictional monstrosity. I've practiced law in Georgia for close to 40 years. Like Robert Bourne here, we both started in 1986. And so I've seen workers that have had to go through the process. I've been to visit their trailers where they don't have electricity, they don't have heat because the system failed them and they're waiting for a decision. And so they lose their family, they lose their kids. So, if we're saving a couple of pennies, on premiums, but you have 10% of the people that are being controverted and not paid their benefits and have to wait 4 or 5 years to go through the federal system. That's an abomination. That should not happen. So if we're basically about family values, about states' rights, about making our decisions here in Georgia, we should protect the workers. Ben Vinson runs a good ship. If it's a Georgia case, then usually the case, it gets set for a hearing within 2 months. Discovery happens, and you're in court within 6 months. You have a decision fairly quickly. That does not happen in the federal system. So do we want to abdicate to this defective federal system, take the workers out of that? I don't think we do. And it's complicated. It's not necessarily just the guys unloading ships. Longshore law applies to people building docks. It applies to people riding barges. So there are a lot of small employers. I see this a lot in Florida. They'll have, all I've got is Florida workers' comp insurance, but I'm running a barge. A barge is a vessel. They should be covered, but they're not. And so because the law is confusing, they don't get the coverage, and then I'm having to go after the employer and have a choice of, do I put them out of business because it was confusing, they didn't buy insurance, or do we just let the case go and the worker never gets any benefits, is usually what happens. So, I think this is an important problem, but I think the current situation with concurrent jurisdiction works, so I don't think it needs to pass. Thank you.
Okay, question.
Yep.
Just a quick question. So let me ask you this question. Is there a way in Georgia law to make it where if you've chosen the path of the federal path, if you start in the state because they're slow, I don't have heartburn with that. Like I've got 100 employees. I want to take care of my employees. So I have compassion for the people because of the timing issue. But is there a way to say you're not eligible if you decide to use the Fed to come back and get the percentage model? Is that something that can be put into code? And I'm not a lawyer, so I figured I would ask.
As indicated, I think the current system works, and I think
Ted, that's not the question. I understand. I know you think the current system works.
I think there are benefits to the.
Is there an opportunity to close Is there an opportunity in law to close that loophole if you have concurrent jurisdiction between the feds and the state? And it would only apply, I'm sure, to this. And what other? Is there any other workers' comp we have concurrent?
Well, as the top lawyer in workers' comp, Vincent, you want to answer Chairman Carpenter's question?
Hey, you've been hiding in the back. Oh, I don't blame you at all. Because I don't want this to appear that I don't have compassion for the employee, because I do have compassion, and I want to make sure my people. I don't even drug test. I'm in the restaurant business, so when my people get hurt, I don't drug test them, because 9 times out of 10 they're gonna fail a drug test. I'm not ignorant. Like, I know what's going on. There's a reason they're in the industry most of the time. So we don't even though the workers' comp guys would ask me to do it, we don't even drug test them, because I want my people to be taken care of. And so I want them to have the access to the quicker funds, but I also don't want them to, if they go down the federal path, to be able to get into the percentage system, because I do think that's an issue.
Mr. Chairman, yep, Ben Vinson, Chairman and Chief Appellate Judge, State Board of Workers' Compensation. I was hiding behind the column trying to not come testify. Representative Carpenter, it's a great question. I don't know the specific answer to your question right now. I would predict that there might be a way to draft something. There might be a way to amend our code to set up some type of process. I don't know the answer right now. I can't tell you that there is a specific block to what you're trying to do. I'm not sure. I can't think of it right now. So it's possible that we could sit down and try to draft something that could work where you might have.
Okay.
And I think, to those who are disappointed that I'm sending this to the advisory council, that is why the advisory council exists. They have 110 expert, subject matter experts that deliberate this. And I know again, people were disappointed it's going to take another year, but I mean, we got this bill last week. And that's why I'm going to send it to y'all. Would like for y'all to deliberate the overall issue, Chairman Carpenter's issue, and come back with a recommendation to this committee before day one.
Happy to do it.
Okay. With that, I don't see any more questions. Unless somebody in the audience didn't sign up and wanted to say something. Awesome. We're adjourned. Thank you very much.